Hello, and welcome to Williams Mullen's Trending Now, an IP podcast. It's a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, copyrights, trademarks, and trade secrets. I'm your host, Clint Brannon, and today I'll be joined by my colleague, Janet Cho, a partner in our intellectual property practice group at Williams Mullen. Today, we're going to discuss how to preserve your intellectual property rights with marking, and we'll be talking specifically about trademarks and copyrights. How are you doing today, Janet?
Very good. How about you, Clint?
I'm doing fairly well. It's been a good day so far, and I hope it continues to be a good day.
Me as well, and I'm excited to talk about this topic with you.
First, I'd like to talk a bit about trademarks and copyrights and what we need to do in terms of marking to preserve our rights there. You frequently see copyright symbols and trademark symbols on items, and I'd like you to give us a little bit of background on how that works.
Yeah, so if it works for you, Clint, I think I'll speak about trademarks first and then about copyrights, because there are some differences between the two types of intellectual property. And I'll just say from the beginning, at least from the trademark and copyright side, when sometimes the word marking is used, sometimes the word notice is used. I'll just use the term mark generally, and it's confusing because we're talking about marking a trademark, but a mark is, broadly speaking, just to start from the beginning, it's just a generally or widely recognized, accepted, or I should say widely accepted symbol that would be used in association with a trademark or a copyright to indicate that it's functioning either as a trademark or it's, copyrighted to someone, and that both of these forms of intellectual property are owned by a particular either individual or company. So it serves, two purposes: to show what kind of intellectual property is at issue, and then that it's owned by someone. So it's not just, generic text or material that can be used by anyone. So if we talk about trademarks, I think people are probably very used to seeing some of the marks that we're talking about, maybe either a little R within a circle next to a mark, or sometimes a little, what we call a superscript SM or TM next to a trademark. So in the realm of trademarks, you're marking the trademark to indicate that it's either registered, which is where the little circle R comes in, or that you're claiming rights, unregistered rights to the mark. So the circle R is used when your mark is registered by the United States Patent and Trademark Office. And I think that, the registration status can be pretty straightforward. I think what I mean by that is you're actually granted a registration certificate by the USPTO. Sometimes I've had clients ask, well, if I have an application pending, does that mean that, I can use a symbol, or my record says that it's registered, but I haven't received the certificate yet? My advice is, certainly if an application is pending, you have not been granted registration, so you should not use the registration symbol. And you should wait until you've actually received that registration certificate to use the registration symbol. And for unregistered marks, you can use a little TM, which indicates a trademark or a mark that promotes a product, or an SM, which means service mark, a mark that promotes a service. So I would say that the best practice is, try and use these symbols for marks that you either have registered or that you're claiming rights in.
And do I have to, if I have a trademark, or do I have to mark with it, or do I have to use these symbols, the circle R or the TM or the SM?
That's a good question. So the marks are not necessary to have rights in the mark, but they are useful for other purposes. So for example, if you have a registered mark, certainly it can serve to discourage others who might want to use or adopt your mark when they see that registration symbol, because other parties may say, oh, hey, this is registered, should stay away from that. The other thing that both the registration and unregistered mark symbols do is that it sets the mark apart from other text. So if you're using a mark within a big long sentence or within a big paragraph, what you want to do is maintain the distinctiveness or the memorableness of your mark. And so including these symbols are helpful to set your mark apart so it doesn't just sort of bleed into other descriptive texts. And I think probably as far as the registration symbol is concerned, where it's most helpful is that if you're in a trademark infringement suit, especially if you're the plaintiff and you're alleging that your mark is registered, if you have not used the registration symbol, you may be unable to recover damages and other monetary relief, because under at least United States trademark law, you need to include that registration symbol if the other party, the defendant, didn't have actual notice of the registration. So it's not required, but it does serve other helpful purposes, which is why I always say, if you can, use the symbols.
Very good. And you mentioned that sometimes the trademark will be kind of buried within a paragraph. Where are the best places to call out markings so that people make sure that they see them and it's clear what you're claiming is your mark? Do you have any best practices as to where the markings should go so that they stand out?
Yeah, that's a good question. I would say that first of all, the question I always receive is, what is the law around where I should be putting these things? So there's no law or regulation that says you always have to put the registration symbol in the upper right-hand corner or the unregistered symbol in the lower left-hand corner. My recommendation is generally to put either one of these symbols, the common law unregistered symbol or the registered mark, in close proximity to the mark so that it's evident what you're referring to. So if you put the symbol too far away from the mark, you have your mark, let's say in the banner of a website, and you've put the registration symbol maybe, 4 lines below to the right, and it's not clear what you're referring to, that is not a best practice. I generally say put it in one of the corners. So upper left or right-hand corner or lower left or right-hand corner. You can also include a little legend. So maybe you don't use the symbol right near the mark. Sometimes you can put maybe an asterisk that directs the viewer or the user to some other part of the involved content. And you can say there that this is a registered trademark of Clint Brannon or what have you. That's also a possibility. I think things like that, at least in the trademark realm, are less common because you have to do a little bit of work to figure out, okay, what does this mean? And I think most brand holders like the idea of making an immediate connection between the trademark claim and the brand. So I would say put it in close proximity to the mark where it's evident what you're trying to convey about the market issue.
We touched on this a little bit earlier, but we discussed several types of trademark marks, and the circle R or the registration symbol was one of them. Could you kind of explain how and when you're able to use that mark versus the TM or the SM?
Right. So when you are granted registration by the United States Patent and Trademark Office, you can use the circle R. I think that's a pretty cut and dry sort of scenario in terms of the registration symbol. When it comes to the unregistered rights, that's probably a bit more fluid and maybe a bit more nuanced. So in the United States, your rights in a trademark arise from your use of it in commerce. You do not need a registration certificate from the USPTO to have rights. So that means that once you start using your designation, whatever it may be, as a trademark, is when you can start using either the TM or SM. And sometimes, depending on the mark, it's pretty evident. So if you have a mark that's fairly distinctive or is a coined term, I think that it's probably easier for the public to determine that, what you're using is a mark. But if your mark is comprised of pre-existing language or words that already exist in English or whatever language you may be advertising in, it may be more difficult to discern what part of your advertising or your communication is, the descriptive part or the textual part and what part is the mark part. So when you've decided that, this is when I'm using this designation as a mark and you as the company deem it as a mark and claim rights to it, is when you can start using the TM or SM.
How does one sort of figure out which of those marks to use today? Because frequently we're having the line between goods and services is becoming blurred. They're being offered as sort of combined offerings. Do you have any guidance on how to deal with that issue?
I agree with you that the distinction between goods and services over time is becoming increasingly bland. I think that TM is used for products that I think most consumers understand as products. So things such as, consumer goods, foods, clothing, things like, computer hardware, things like that. I think where the blurring comes in is probably most likely in the technology space and in the software space. And sometimes it can be very difficult to determine if software is treated as more of a good or a service, especially if you're, not dealing, if this is a new product or service to you or you're, new to the business. Generally, downloadable software is considered a product and non-downloadable software is considered more of a service. But that said, most people who are not practitioners won't remember those kinds of nuances. So my general advice is if you're not clear or you're not certain whether what you're doing is a product or a service, or perhaps you don't want to have a separate set of markings, one for products and one for services, just from a marketing perspective or a cleanliness of look perspective, you can always default to just putting TM, whether it's a product or service. You won't necessarily go wrong with that. There's no punishment for, putting TM if you're promoting a service. So it's more to set the expectation of the consumer and, make it a little bit clearer what you're promoting, but you can always default to TM if there's uncertainty or if you just want to make the same claim over and over again in your advertising. Does that answer your question, Clint?
Yes, thank you. That's very helpful. And I think that helped me understand that default to TM if you're uncertain is the advice.
Yeah.
So now that we know a little bit more about trademark marking and symbols, can we go through some of the requirements on the copyright side and what issues we have to deal with there?
Yep, absolutely. So I will say from the outset that copyright markings are a bit more complex than trademark markings. And that's because under copyright law, there are different requirements depending on when your work was created. So there was a time when you needed to include some markings in order to have copyright rights. And now under most recent law, that's not required. So I will say to keep things simple, we'll focus on the most recent iteration of copyright law. So talking about things that were published or created after March 1st of 1989. And that's that's several decades before this current time. So I think that will loop in a lot of, fairly recent works. But I'll focus on things that are published after that date. And for things published or created after that date, copyright notice is optional. So it's not anything, the formality of including the notice is not required for you to have rights. So I will say for unpublished works, notice was always optional, even, at the turn of the century. But now the notice is optional, certainly for unpublished works, foreign works, or works published on or after March 1st, 1989. And copyright owners do not need the Copyright Office's permission to include notice now, but it's generally considered helpful. And the notice I would say that you'd want to include consists of 3 elements: the little circle C symbol, for lack of a better description. So, it distinguishes what we're talking about from, copyrighted works as from trademark rights, the year of first publication of the work, if it has been published, and the name of the copyright owner. So very often you might see that, especially on a website or on a document, the bottom of the page, you might see a circle C with, say, Clint Brannon 2017. So I would say it's not necessary, but helpful. And that's an important thing to know.
If notice is optional, as it was with the trademark marks we discussed earlier, what are some of the benefits of actually taking the effort to put the copyright markings on?
Yeah, I would say in copyrighted work, as with trademarks, one helpful benefit is that just as a general matter, you're giving the public notice that what's at issue is owned by someone. I think, to your point, when we were talking about the distinction between goods and services becoming more and more bland over time, I would say the prevalence of content on the internet has also created this scenario where many people think, well, if it's on the internet, then it must be freely available for use. And that's not necessarily the case. So the notice, just at a minimum, lets the public know this is a work that someone has created and is claiming rights in. It's also helpful because if you want to use that work, then the notice typically has the owner's name, identifies the owner, so you can approach the owner if you want to get their permission to use the work. It also, if there's the date of publication included in the notice, then it's helpful to determine the term of copyright protection for works such as anonymous works, pseudonymous works, or work made for hire. And finally, and this is probably more of a rare issue, but including the notice may help a work from becoming an orphan work and identifying the copyright owner. So there are benefits. It's not necessarily the vehicle through which you obtain rights, but there are benefits to it. And I will say, I think most parties like to include it because they feel that it's more of a form of attribution. And so I think most parties that I've spoken to like to include it just as a not only as an enforcement issue to keep parties away from using the work, but it sort of gives attribution to the author, whoever that may be.
Are there any particular requirements as to where I have to place the notice in my works?
Well, as with trademark marking, there isn't a mandatory place or manner to include as to where to include the copyright notice or mark. But I think one common area is generally at the bottom, either of a page or of a website. That's usually where people are used to seeing it. But again, as with trademark marking, I would say include the notice in a manner that makes it clear, what we're talking about and who is the owner. But I think it's always helpful to put it at the bottom of your content because that's usually where most people, I think, expect to see it.
And I think we've been talking about the law in the United States on these issues. Are there any general rules that we can take and apply to marking in other countries?
I would say that just don't assume that what you're doing here in the United States is applicable or sufficient in other countries. And especially from the perspective of those who may say have a registered mark in the United States and then have a registered mark in another country and have, say, a copyright registration in the United States and in another jurisdiction, that you should definitely, consult with an authority in the other jurisdiction to make sure that your marking and your notice is consistent with law, because there may be some similarities, but it's very rare that the law aligns perfectly. So, my best advice is don't make any assumptions. So don't do what you're doing here and think that it's sufficient in your other jurisdictions of interest.
Thanks. That'll wrap up part one of our discussion on how to preserve your intellectual property rights with marking. I'd like to thank Janet Cho for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our IP practice webpage at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast, and read many of our legal alerts. Please be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening. Until next time.